up to lawsuits. We are opening up ourselves to, the unknown, because the law is not on our side. The law does not state that we will not be responsible if something does contain lead. Even though we understand that we won't have to test it, it still is leaving us liable, and the intent is wonderful, and I believe that in time it will get worked out. But February 10th is next week, and we have employees in our communities. We have people that are relying on their jobs as well as our businesses and what we need to do to survive, and our consigners who have come to us, and or sellers depending on the business, that are relying on that extra $25 a week. It seems petty, but it's that $25 a week that's paying for ballet lessons for that child, that's being, the pizza shop, that we're supporting the pizza shop on the corner in our hometowns. And it's that money, and it's those little things that are the quality of lives in our children and in our families. And when you're taking that opportunity away, and the government turning around and saying, oh, you're responsible, it's wrong. It's wrong at every level.
It's a question I can't give you a definitive answer, because there would be a decision by the Attorney General, looking at the guidance that the Commission has put out of saying, we're requiring testing for another year. The Attorney General in any prosecution, whether it be a civil remedy sought or a criminal remedy, has the discretion of looking at all the facts and deciding on any issue how to handle it.
Okay.
I would expect the Attorney General is going to say, well, the Commission has delayed testing requirement for a year, certification requirement for a year, and so heed that decision and the recommendations to focus on enforcement on recalls. That doesn't mean that we'll do that. That would be my read, but that's a question that ultimately the only person who can answer it is the Attorney General.